My guest at this time is Andrew C. McCarthy, former federal prosecutor, contributing editor and columnist at National Review Online. He's a Fox News contributor. He's a New York Times bestselling author. The forthcoming book is Ball of Collusion, the plot to rig an election and destroy a presidency, which we'll get to soon, but not today. Today we're talking about the gun debate and what legislation could actually address these mass shootings in a constructive way that still preserves Second Amendment rights. That's what Andy writes about in The Hill this week. The title is Red Flag Gun Laws Are Constitutional and Sensible. Andy, it's good to have you with us as always.
Thanks so much, Greg.
Well, we've heard this term a lot now in the past few days, unfortunately, since these horrific shootings in Texas and Ohio. I know your colleague at National Review, David French, has written about this a lot. He calls them gun violence restraining orders. But define the concept here. What's at issue?
Well, the idea, Greg, would be that if somebody exhibits the kind of behavior that would concern reasonable people in terms of the person's access to firearms, they would be able to, whether it was through the police, some versions of this would only allow this through the police. Other versions would let anyone make the application, but you'd have to make an application to a court, and the judge, on some standard of proof with rigorous due process protections for the person who is at issue, would have to make a determination whether to cut off that person's access to firearms for either some finite period of time, or, depending on what the disability was and the proof of it was, it could be longer than that.
So let's dig into some of the issues that you raise and that people who are a little bit skeptical of this idea raise. First of all, who should be allowed to allege that a person is a threat? This question has come up by some Trump supporters who are looking at stories where Trump donors are being harassed, and so they envision a situation where I just don't like this guy. I want to make his life miserable. Let's take care of his guns. How do you avoid situations like that while still allowing real threats to be addressed?
Yeah, I hear all that, and I think it's very important. At the same time, there's no law that you can make that can't be abused, and no system that you have where the processes can't be abused. So we think, for example, that our civil litigation system is vital. We also know that it gets abused, that people can file vexatious lawsuits. And, I've always thought, Greg, that there are things that can be done about that to minimize it. And I certainly think there are things that can be done about that to minimize it here. I would think that, if there were frivolous applications that would be made, number one, there may be a quantum of evidence that you would have to satisfy in order to even get in the door. And that's why some people suggest that you should only be able to go through the police, and that may be a good idea. But I've always thought that we should explore things like, loser pays lawsuits, and that there should be some real teeth in what we in federal practice call Rule 11 sanctions. There's a rule of federal civil procedure, Rule 11, which says that if somebody files a frivolous lawsuit simply to be a vex on the person they're filing it against, they can be fined for doing that. I think it's unfortunate that judges don't make more use of that provision, but I think those kind of needs can be addressed. To my mind, if you're going to say that because laws and processes can be abused, we should never use them, then that's just a complete non-starter. We'd never have any laws or rules.
We're talking with Andy McCarthy, and we're talking about red flag laws. And Andy, you mentioned having appropriate due process. And so one of the things that came up whenever the idea was raised to, hey, if you're on the no-fly list, you shouldn't be able to buy a gun. And the point is made that, some people might not be on there for the right reasons, and they have their guns taken away and that sort of thing. So in this approach, would you lose the guns until it's adjudicated, or do you keep the guns until it's adjudicated? How would this due process be most appropriately set up, do you think? Well,
I to my mind, Greg, you would have the because we're dealing with a constitutional right here, I could see that you could have an emergency application where, in the judge's discretion, if you made enough of a showing in the first instance, that the guns could be held in abeyance until the judge had a chance to hear the matter on an expedited schedule. But I would be in favor, because we're dealing with a constitutional right, that the person would get to keep his rights until a quantum of evidence was presented to a judge that satisfied the whatever standard we imposed. I think the failing with the no-fly list is that so much of that is based on classified information, and the process for getting a person removed from the no-fly list was maybe even illusory. At the very least, it was impossibly difficult. The due process was virtually lacking, and that's the real problem with it. I don't think that people in principle, for the most part, have a problem with the idea of the no-fly list. What the main objection was, and it was one I share, is that the process for an innocent person to be removed from the list was almost non-existent, but certainly very difficult.
Andy, one of the other issues, and you brought this up a moment ago that you address in the piece, is ultimately, how do we decide, once we get this person before a judge or some other venue, whether or not they actually do pose a risk? You say, how do we really know that a person presents such a peril that the denial of his Second Amendment rights can be justified in the absence of criminal or other disqualifying conduct? To be sure, we're only human, and our powers of prognostication are highly fallible. It's certainly possible that a person could be unjustly deprived of firearm rights, just as a person can be unjustly convicted or falsely arrested. Nevertheless, the fact that mistakes and abuses are inevitable does not mean they are routine. We know they are not. And the fact that we cannot predict the future with certainty does not render us unable to address its plain-as-day possibilities responsibly. Indeed, we are obliged to do so. So what type of evidence do you think would be appropriate for a judgment to come down saying, yes, this person is a danger, we need to at least temporarily remove their firearms?
Yeah, well, let me give an analogy, Greg, which I also lay out in the piece, because I think people need to understand this is not an unprecedented idea or a radical idea in any way. In every single criminal case, I mean, I should preface this by saying that the objection that I hear most often connected with the point that you were just raising is that you're asking for a predictive judgment. I think that's the way Professor Alan Dershowitz puts it, that you're asking for a predictive judgment in connection with a person who hasn't done anything yet. You're basically just in fear that he'll do something. And, my answer to that is that in every single criminal case, a judge has to set bail. And bail is essentially a constitutional right. The Eighth Amendment says that you can't have excessive bail, and that's normally thought of as a presumptive right to bail. And yet bail can be denied in a criminal case on the basis of a judicial determination on a particular standard of evidence, whether it's more probable than not, or preponderance of the evidence, or clear and convincing evidence. I think here it's usually clear and convincing evidence. But the judge can deny bail if the judge is satisfied that the person is a risk of flight, meaning that there's considerable doubt about whether he would make his court appearances if he was given bail, or if he's a danger to the community, which under the law means that you could be a threat to witnesses or a threat to the process, or even that you're simply in a criminal status where you could pose a danger to people in the community, like somebody who's a high-ranking member of organized crime or a drug cartel or what have you. So these kinds of predictive judgments are called for and made in every single criminal case, because every criminal case ends up involving a bail determination. And I've been in cases myself, particularly terrorism cases and organized crime cases, where the defendants were detained as both risks of flight and dangers to the community, and they did not get out of jail prior to trial, notwithstanding that these were very complicated cases in which the case ended up not going to trial for well over a year, in one case over 2 years. So it's not like we never make these predictive judgments or that we don't intrude on rights that are every bit as important and probably more important than our firearms rights. And I'm not trying to minimize firearms rights, but we're talking about, the very right to liberty here is denied to people on a predictive judgment. So that kind of thing goes on all the time. And, the fail-safe for it is that if a judge makes a bad call, we have a very extensive appellate system as well, so that it's not like the judge would make an order and there's no recourse after it. You would have your full appellate rights. And if I were making the rules, I would also give the person who was subject to an order like this the right to counsel, just as if he was a criminal defendant. In other words, you would not have to retain counsel. You would have counsel provided for you by the state. I think there needs to be rigorous due process. But the idea that we can't do something like this on a predictive judgment, I think, is defied by the everyday reality of the criminal justice system.
Well, and that's what a lot of people want, of course, is the ability to preserve the Second Amendment rights while also trying to keep weapons out of the hands of people they believe are a serious threat. And we've certainly seen some of these mass shooters. The Parkland shooter comes to mind, certainly, where everyone afterwards says he was, likely to be this type of person. They even talked about it. So one of the things that David French talks about in his most recent piece on this is a good idea, but we got to make sure it's drafted properly. So what are some poison pills, perhaps, to look out for, as, of course, Republicans and Democrats would have to come together since each party controls one chamber of Congress?
Well, I think, Greg, you've raised the most important one, which is that it can't be very easy to make this application, because I think you're quite right. If it is, we have a long history of people who are willing to, especially interest group connected people who have a philosophical opposition to Second Amendment rights and who think that God is on their side and therefore, well, if they believe in God, but in other words, they think they're in the right, and it doesn't matter if they go in and they file a frivolous or a dishonest petition because they're on the side of all that is good and just and right. And I think that is the biggest hurdle. You have to have a real and colorable threat. So I think what probably Congress should think about doing is itemizing the kinds of behavior that would justify a motion and require a fairly high standard. I'm not saying beyond a reasonable doubt, but I think we do have to be mindful of the idea that there could be frivolous petitions. And again, as I said before, what I would do is I would very seriously consider having a loser pays provision, so that it would cost people who made these frivolous applications. And I would also I wouldn't rely just on Rule 11. I would write into the rule that if a court were to find that a petition like this were made frivolously, that the court would have the power to impose fines or sanctions or what have you. So I think the biggest thing is the ante, the threshold for getting into court in the first place, and that would ensure that really the only petitions that got into court and were seriously considered were situations where there really is actually something colorable to worry about. And then what I would want to fashion would be a right to counsel for the person who is the subject of one of these petitions, and a stiff enough standard of evidence. I like clear and convincing, which is usually the standard that we use in bail proceedings. And the other thing I would write into the law, Greg, is that the person against whom the order of this kind were entered would get periodic review from the court. So, whether it was every, depending on the circumstances of the case, whether it was every few weeks or every couple of months, the situation could be revisited. And that way, if the disability were being caused by something that was emergent rather than, some kind of serious psychological condition. Let's remember, when there is a psychological condition, there are independent ways to deny someone of a firearm. To get the person adjudicated as incompetent, then your loss of firearm rights is kind of a collateral consequence of that. But what I'd be concerned about is the person who has some kind of a temporary disability, like, for example, a restraining order in a domestic relations dispute, where people may be very hot-tempered and it may be a highly stressful, highly emotional situation at one point in time, but maybe it won't be 2 months from now or 6 months from now. So I think it should be periodically revisited as well.
Andy, last question. It's hard enough to get all that together for one bill, much less 50, but as our constitutional guy here, is this more appropriately done at the federal level or at the state level?
Well, I think it's more – I would prefer to see it done at the state level for two reasons. One, most of these cases, Greg, are going to be state cases. And number two, the only way the feds can really do this is kind of by either bribing or extorting the states into doing it, which I always think is inappropriate. So, I can see where Congress, everybody gets seized after these terrible shootings, just like they do after every terrible event, with the idea that we have to do something. We have to show people that we're doing something. And I think it would be incumbent on Congress to do this kind of legislation, both for model purposes and because there are federal firearms provisions. So it's not just a situation where there are only state firearm concerns. But I really think this is the kind of process where you would like to see the states not only enact this kind of legislation, but give them the freedom to do it, in different ways, so that we over time get to see what the best regulatory model is.
We'll certainly be watching. There's a lot of talk about this now up on Capitol Hill. Senator McConnell was just talking about it on Thursday, and Lindsey Graham, I know, is a supporter of this. He's the chairman of the Judiciary Committee, so we'll see what kind of traction it gets once lawmakers return to Washington after the summer recess. Andy, always great to have your time and your expertise. Thank you.
Thanks so much, Greg.
Andy McCarthy, former federal prosecutor. He is a columnist and contributing editor at National Review Online. He's a Fox News Channel contributor. He's a New York Times bestselling author. The upcoming book, Ball of Collusion, The Plot to Rig an Election and Destroy a Presidency. I'm Greg Corombos, reporting for Radio America.